public comment in Reno?
No more comment.
Public comment in Las Vegas?
For the record, Chad Foster, Douglas County Cab. First of all, I just want to say that when we spoke about this workshop item on Monday, we were all in support of this item, just because it would give, to us at least, hunters more opportunity to obtain tags. Secondly, I would like to ask a question to see what, or if there has been a study done of what the financial impact of lowering the wait times would be for the department. Thank you.
Thank you, Chad. Further public comment in Las Vegas?
For the record, Paul Dixon, Clark. We did not actually have this on our agenda this time.
Mike, please.
We did not actually have this on our agenda for this, for our last meeting, but we had discussed it at the previous 3 meetings and all the way through the TAC committee on this. And we had pretty much an unwavering acceptance every time that we were pretty much a cab in full agreement with the decisions that came out of the TAC committee, and therefore it wasn't on our agenda this time. But I'd never heard, at least from Clark, which has the second largest tag submitting community in the state, if not the first, heard any complaints that came through our cab about going to a standardized wait period of 3 and 3 for antelope or 5 and 5 for elk. Thank you.
Thank you, Paul. Further public comment in Las Vegas? Hearing none, I'll bring it back to the commission. Any further public or comment from the commission? Commissioner Drew.
I'd like to address just one question that got made, and Mr. Foster brought it up from Douglas Cabin. I think the question was on economics, and this has come up several times. I've been approached by people in public that, you know, the department's looking at this to raise revenue, and I think there's no doubt that we'll likely raise revenue. But to be honest, in these discussions, and it frustrates me every time it comes up, I don't want an economic analysis because it makes absolutely zero impact in my personal decision making. I can't speak for anyone else, but no, I don't believe an analysis has been done. I don't need one to move forward personally, and I want to dispel that that is the primary driver of this, because in my opinion it absolutely is not. It's something that was brought through public participation through the cabs, and we're running it through the process. And so, you know, for those who think that's the primary driver, I think it's either a misunderstanding or people clearly not being involved in this process.
Thank you, Commissioner Drew.
And I can confirm there was no discussion of the financial impact or what that would be at the TAC committee level. I did jot down some numbers. Mr. Flowers commented on some of the numbers, and I just did some quick calculations, and they confirm if you take roughly 1,300 elk tags and over 10,000 applicants, it's roughly 12% of the applicants are going to draw a tag. If you put people and you shorten the waiting period by 5 years, it's going to take that 12% number down to about 11 or 10%. Antelope, it's be like 13, 14% of the applicants will get a tag, and with the shorter waiting period, it'd go down to like 11, 12%. So those were the numbers, and I just did quick calculations. Refreshes my memory as to what we were looking at the TAC committee when we were looking at the number of tags and number of applicants. Mr. Valentine or Commissioner Valentine can correct me if I'm wrong. He's on the committee too, but that confirms what I was going from memory earlier in terms of when we looked at those numbers, just a number of applicants versus number of tags, and how it was a small percentage, 2 percentage points or right around that area in terms of the ratio. So,
Thank you, Commissioner Johnson. Any further comment?
Brad, you know, my question is, has anybody ever thought of or looked at why somebody buying a landowner tag doesn't have a waiting period? There's an ethical and moral question there to me. Why do we have any waiting periods for anybody if a guy can afford to buy one every year? What's the point of that?
the issue of landowner tags and waiting periods has not been addressed. I can certainly put it on we can take that to the committee and see what the
So if you
committee does
eliminated-
with
yeah,
it.
If you eliminated all waiting periods, everybody has the same shot. The rich guy that can buy it every year and anybody else. But I want to know why there's never been any thought put into somebody that buys a tag every year, doesn't have a waiting period. They killed a trophy bull elk. If somebody that killed one has to wait 10 years because they didn't have the money or can't afford to go do it every year. And I think there's a dilemma there, at least there is for me, that person does not have the waiting period. I don't have a problem with buying a tag whatsoever, but why don't they have the waiting period like everybody else? And that should be a question that should be answered by that tag.
We
in my mind.
we can put that certainly to the tag committee or to the landowner tag committee. I mean, that's something they can look
And it
at.
will certainly upset a lot of my friends that go buy a tag and kill 1 or 2 elk every single year. But I just want to have an answer to the question why there's no wait for them. Just like anybody else that puts in. It's still a resource that is taken from the state of Nevada that belongs to all the people. And if that's the reason we have a wait period, where's the balance there?
I think you also have to hear from the landowners on that issue too, because they want to maximize the value of their
Well, they still
landowner
get the
tags.
They can
They still get the tags,
sell it
but
to anybody they want, but if somebody continually buys one year after year or buys 2 or 3, why don't they have the wait period?
I don't have an answer to that question, and we haven't addressed that topic at the TAC committee. And I think you're going to have competing views from the landowners that that program is designed to compensate them for the number of animals, and that they want to maximize that value of that tag for that compensation, and they don't want to eliminate people who may want to come every year and give them a couple, few, 10, the varying values depending on where it's at. I don't know the answer to the question. We have not examined it at the
Trust me,
TAC
there's an
committee.
unlimited supply of those guys that will still be lining up to buy those tags. It's a matter of that the same people get them over and over and over. There's plenty of rich guys that want to get them. They just can't get to them because they're tied up.
All right, guys, I think we're getting a little off topic
Yeah,
on that.
okay.
Commissioner Allenberg?
Commissioner Brad answered he responded what I was, my
Commissioner
thoughts.
Drew?
Just as kind of a point of order, Maureen, maybe you can answer this for us, but I don't know that this NAC deals with that, and I don't know if the NRS that implements those incentive tags speaks to waiting periods or not, but my guess is it's probably something for another day to discuss. It's not contained within this NAC.
This particular, Maureen, for the record, Maureen Hollinger, Nevada Department of Wildlife, this particular regulation pertains to the draw tags. This is strictly in the section of 502 for draw, so.
Commissioner Hubbs?
Just out of curiosity, is this a normal normal period of time for waiting for the next opportunity to apply in other jurisdictions? I mean, is it outside of the norm, or I'm just trying to get a feeling, as I don't deal with this day in and day out, how abnormal this might be to only wait 5 years versus 10 years. That's a pretty substantive period of time.
I don't have the answer for that.
I have a partial answer. There's a lot of states that have 0 waiting period for some of these species, a lot of western states. I think there are also some states that do have similar waiting periods, and it's just purely a function of the supply and demand. Colorado, Wyoming, for example, that have a lot more elk. Montana, you can get a tag every single year, but they have a much greater resource, and their demand in some cases outweighs their supply. Wyoming's the same way with antelope. Arizona, Utah, I think they have some waiting periods. They're maybe shorter, but again, they have more animals. So it's a little bit unique to Nevada in some ways, but it's in no sense unprecedented.
Further comments before we move on to the next item? Seeing none, I'll close item 15 and move on to agenda item 16. Commission General Regulation 467, Special Assistance Permit, LCB file number R105-16, Chief Game Warden Tyler Turnipseed, workshop, public comment allowed. The commission will hold a workshop to consider amending Chapter 502 of the Nevada Administrative Code through Assembly Bill 136 of the 2015 legislative session, the Nevada State Legislature mandated the Board of Wildlife Commissioners to adopt regulations prescribing the circumstances under which a person may assist a licensed hunter with certain disabilities in the killing and retrieval of a big game mammal. The commission held a workshop on this regulation change on August 12, 2016, where several changes were considered. Mr. Turnipseed.
Thank you, Chairman Wallace and members of the commission. Again, Chief Game Warden Tyler Turnipseed for the record. Chairman's correct. This regulation is a result of AB 136, the last legislative session. Essentially, what AB 136 did was mandate that the commission shall make regulations to allow for the retrieval and pursuit of a wounded big game animal that was wounded by a disabled hunter. And the disabled hunter sideboards were put on it as someone who's got, an amputee or severe paralysis of one or both legs that severely impedes their walking. So, again, we had that workshop last month, discussed several changes, so I'll turn it over to Captain Maynard. Mike Maynard with our law enforcement division. He'll go over some of the changes that were talked about. Those were easy enough to plug in. With the exception of there was a discussion about how many people would be allowed on that assistance permit, how many assistants, how many rifles, and so Captain Maynard will go over those options with you.
Captain Mike Maynard, Law Enforcement Division for the record. Mr. Chairman, Commissioners. I'll go through real briefly the changes that we brought up last time around, and then we'll focus on the multiple assistant issue, which was something that was still kind of in the air, and come up with what we believe would be acceptable language. If you'd like to look at the proposed changes that were submitted as support material, I'll go through them from the Legislative Council Bureau's version. There's some handwritten notes that address those changes that came up last time. Basically, in the first section, second section, third section, there's really no changes. Those mostly dealt with the definitions. When you get down to section 4, at the very bottom under 2.6, you'll see they wrote in 7, a certificate issued by a licensed physician certifying that the applicant has a permanent disability. We brought this up last time. That mirrors language found in NAC 503-146 and 146.5. Already has that identical language. This would just incorporate that into this regulation and make it a little smoother as far as its application and enforcement. The next part to skip down, actually, the multiple assistant will go under subsection 3, where it says an applicant for a special assistance permit pursuant to this section who holds more than one tag issued by the department authorizing the holder to hunt a big game mammal must complete a separate application for each tag. The applicant is not required to use the same designated licensed assistant for each tag. I can go ahead and hit that now. Basically, the language that I got from watching the video over and seeing the commentary from the commission was there would be one primary designated licensed assistant and 2 alternate designated licensed assistants allowed per permit. And the key language that would be added would be only one person may act in the capacity of a designated licensed assistant in the field at a time. There's a couple variations of this. This is the proposed language that I kind of parsed from the video. There can be 2 designated alternate assistants, or basically that number can go up. It doesn't really matter. There could be 18. I mean, I've talked to Maureen Hollinger concerning the permit, and there's not a problem putting additional designated licensed assistants on the permit. The key issue that we're concerned about, especially from a law enforcement capacity, is that only one person can act in that capacity in the field, specifically addressing the permissions given by this permit, by this NAC, which would be the ability to pursue a wounded animal, use a weapon on that wounded animal, tag that wounded animal, punch the tag, etc., attach. That we only want one person at a time. There's a bunch of nuances we could throw in there with that, but essentially only one hunter should be shooting at the animal at a time. We don't want a case where this person has 3 assistants and all of them are opening up on one animal in the field at the same time. That goes well beyond any fair chase or reasonable wording in the regulation, we feel. That would be the final language that would really be of note with this presentation in this workshop. I'll touch on a few other issues, but basically those were all accepted without comment. I'll come back to this in a sec, but moving down on section 5, basically it just says that they have to carry a copy of the permit with them. Each assistant would need to have a copy of that permit in their possession while in the field. Going to the next page under section 5, subsection 2, under 2A, the designated licensed assistant must be accompanied at all times during the hunt by the disabled tag holder who has a special assistance permit. This matches the language in NRS 502-149. In that case, we took language from an existing NRS which has attendance or accompaniment by an assistant of some sort and just mirrored that. Less confusion. We feel that makes the regulation go a little smoother. On the next page, by subsection 6, or just above subsection 6, all persons listed on such permit shall present the permit upon request of a law enforcement officer. Again, that's standard language that we find in NAC 503-146 and 503-146-5. They have to be able to present that permit, and that provides multiple protections for the designated assistant that may be in another canyon and is getting checked by a law enforcement officer. And there's a lot of possible issues that could come up, but basically possession of the permit and producing that is consistent with all our other permitting requirements we have for being in the field and preventing any problems from coming up. Back to the main language change, which I would put to you is how many assistants you wanted on the permit would be allowed, and specifically the proposed language that we would suggest is that only one person may act in the capacity of a designated licensed assistant in the field at a time. So that's all I had. I'll stand for any questions if you had any.
Any questions by the commission? Commissioner Hubbs.
I just had one on page 3 on section 4D. The only reason I flagged that is because I stopped and read that about 3 times because it caught my eye. The very first sentence, and when it says to be a designated licensed assistant, a person, and it gives you certain things that person must be. And D says is not required to hold a tag for the big game mammal, which the holder of the special assistant permit is authorized to take, which if you look at it collectively again and read through, you understand there will be a tag, but the licensee does not have to have a tag. But the way I remember us talking about it in the past, obviously if you're going out and chasing a wounded animal, the licensee at that time should grab the tag, right? And take it with them?
The permit that we're going to be issuing is going to obviously have language that refers back to this that will give them a reason to be pursuing the animal. I can't predict the circumstances on how far away they would get. It would be reasonable to assume that if they were going to pursue it and have to take that animal at some distance from the tag holder, that yeah, they would need to have the tag with them in order to punch it and attach accordingly. If it was walking 15 feet over the side of a hill or something like that where the disabled hunter simply couldn't get, or if they were unable to leave a vehicle, for example, if that was their limitation, and the animal was simply moving out of their range of fire, it wouldn't necessarily be something that we would concern ourselves with in law enforcement, as long as they had a designated licensed assistance permit with them that would explain while they're pursuing the animal. We're going to look back onto where the tag is if it's not with that person.
Okay.
Commissioner Drew?
I think the other thing to keep in mind too is even though it says to hold a tag, and maybe there's some language we could clean up, basically, it wouldn't be in the tag wouldn't be in the assistant's name.
Right.
But, physically, whether the assistant or the hunter has the tag, I don't.
Right, and that's, I think
think
once you
that's-
read it and you slow down, you understand what it is, but it could be just for the way that it's written, holding in your hand, holding in your name, and from the conversations we had before, at all times, they're supposed to be acting, if they're out as the licensee, if they have to take the animal, as if they're acting in place of the disabled person, which would always have their tag on them, right? So it's just, I think it could be clarified so there's not that error.
Further comments from the commission? Commissioner Johnson.
I just had a question on the bottom of page 2. There's the handwritten language about the certificate issued by a licensed physician, and it says that the applicant has a permanent disability. This regulation, however, is not available to anyone with a permanent disability. It's defined as someone who's a paraplegic, has one or both legs amputated, or who has suffered paralysis. So it seems to me that the physician's certificate should be certifying one of those 3 things, not a permanent disability.
That was language that was mirrored in other permits for other various disabilities, and is probably a little bit, I don't know, more consistent with the direction we've gone in the past with the most recent regs that we've addressed this with, that this isn't just a temporary passing thing, which granted, for an amputee or somebody who's a paraplegic, one could assume that that's a permanent disability.
I guess my concern is there's a lot of permanent disabilities that people have that do not qualify them for this permit, which is limited to 3 very specific things.
Correct.
So that's my concern. I'm not suggesting that any of the things in this are not permanent disabilities, that there are just other types of disabilities that a physician could certify that are not these 3 specific items that this regulation addresses. So I would want to see a certificate issued by a licensed physician certifying that the applicant is a paraplegic, has had one or both legs amputated, or has suffered a paralysis of one or more both legs, which severely impedes the holder's walking. I really believe that should mirror the language in Section 4.
Yeah. We can move the language up to under that section, or we could just.
Mike, please. Please speak in the mic, please.
Oh, I'm sorry. We can move the language up underneath that section, which directly gives the authority to the person who is a paraplegic. Or, as the chief just pointed out, we can just take the permanent disability language out and put met the requirements of Section 4. That's easy enough.
However, I don't care how it's specifically worded. I just wanted to make sure that the physician is certifying the requirements set forth in Section 4 that allows someone to then have the special assistance permit.
Of course.
Commissioner Drew?
Just a couple minor wording items. I think on page 3, with the inserted language, it says, "and the listed designated assistant who are in the field." And I think we may, since we're going to the potential of having more than one designated assistant, just saying, "and each listed designated assistant that is in the field."
And that'll depend on what you decide you want for the final language as far as how many assistants are listed.
Right.
That would affect that language, obviously.
And then in item 4, where the new language is put in there, kind of gets to the same thing, but I think we want to make sure that it's the acting designated assistant has to be accompanied at all times. That way you don't have a group of 10 designated assistants that all have to be in one place at the same time. So I think we just need to clarify that it would be the acting assistant that would have to be accompanied by the tag holder.
Sure.
Commissioner Valentine?
Thank you, Chairman Wallace. I don't know if any of the other commissioners had any confusion or issue with the item on page 4, 2A, the designated license assistant must be accompanied at all times during the hunt by the disabled tag holder who has the special assistance permit. Do you think there's a possibility we can clarify must be accompanied at all times during the hunt? Because obviously you can't be accompanied at all times. Am I the only one that's?
That language was brought up the last workshop, and basically we changed it to, from close proximity to accompanied. And the reason I referred back to the language in NRS 502-149, which was a guide for a non-resident on a special deer hunt, the reason for that change in language was accompanying in the field under the interpretation of that already existing statute. Our officers are in the understanding that you don't have to be within 30 feet of them. And there is going to be a certain level of ambiguity as to how close can you be. We understand, and our training of our officers on enforcement of this reg is going to be that basically as long as they're in the field and they're acting in that capacity, we understand that they may have to go over a ridge, potentially a mile or so away. The interpretation that we would hold to it from an enforcement perspective is the tag holder can't be at home on his couch. He has to actually be out in the field and in a reasonable proximity. As far as what reasonable is, it's hard to put limitations on that without really restricting the parameters of the hunt to a point where it's not really of any great benefit. So it's language that can obviously be adjusted. It depends on what you consider the acceptable parameters to be. That's how we're going to interpret it from an enforcement perspective with the existing language. That's how we would go out to our officers and train them on that.
Further comments from the commission?
When I read it, that's what I thought it meant, like accompanied, meaning they're in the field together, not that they're side by side, because you can't fulfill the role of the designated assistant in all terms under this reg by always being side by side. There's going to be, but as you said, someone can't be back at the camp and the other person one out in the field. So they're certainly not at home.
Okay, further comments before I take it to public comment? Commissioner Hubbs.
Maybe we could say something like participating in the hunt. I mean, or something of I could see somebody back at the camp, honestly, and then trying to use that a bit later. I don't know. I just, in some way, having them as an active participant in the hunt at all times. I mean, we know they can't. I mean, that's the licensee, right? Because they can't go some places the licensee will have to go, but they should be participating or actively involved or in some way out in the field, because in the hunt, for somebody who's having their, buddy run around as a licensee agent and he's back there at the tent, you don't want that either,
All right, I'm going to take it out to public comment in Elko.
No comment in Elko.
Public comment in Reno.
Yeah, Joe Young, Carson Cap. I think there's got to be some association between the degree of disability and the requirements on the assistant. I mean, if a person's a paraplegic, he's got to have help all the time. If a person is just confined to a wheelchair, it's a totally different situation where the assistant can be some distance off while the participant who has the license, uses the particular weapon and goes after, takes a shot or lets go an arrow at the game, where in other cases, the first individual would need help in firing the weapon or releasing the arrow or the bolt and then retrieving the game. So I see the challenge that you have in trying to cover all these issues in all
Thank you, Gil. Any further public comment in Reno?
No more comment in Reno, Chairman.
Thank you. Hearing none, I'll bring it back to the commission for some direction for the department. Oh, I'm sorry. Public comment in Las Vegas. Now you gotta talk, Paul. All right, now back to the commission.
I guess one other comment I have, I like the idea of only one person being able to fulfill the duties, but you could have a number of people identified who could fit that role. And if we're going to go down that path, then I don't think there's a need to put a limit on the number of people who could serve in that capacity. I think we talked about that in the past. People have to cancel plans. You could put it, 5, 6 individuals who would be willing to help out the qualified individual, but limiting it to only one person in the field, I think addresses that problem, so we don't have 5 people going after the same wounded animal, just one. Even if all 5 are in the field, all 5 are eligible, they pick one. So I don't think we need to limit the number of people who could serve, but certainly the language to say, if this happens and someone has to perform this role, it's going to be limited to one person. So that's where I stand on that issue.
Commissioner Drew.
And just to follow up, the language you provided us would basically allow an unlimited number of designated assistants, but only one acting, correct?
Well, and that's kind of where it goes to you folks. The commission would need to decide if they want to, how wide of a loop they want to throw on availability. Our internal discussions, we have no problem accommodating people. This is what this regulation is about. And having multiple people as potential assistants available, should one get sick, get hurt, not show up because of a work conflict or whatever, having multiple people available, as long as they're listed on the permit, there's nothing that's going to be harmed by that. And as long as, again, you look at the language that limits it to one actor, I think we're in good territory.
And correct me if I'm wrong, but right now the regulation or the mock-up we have in front of us does not have any restriction in terms of the number of assistants, correct?
Right now, the LCB version, I think, limits it to 1. And we want to add the language that there will be 1 primary designated assistant, and then we put 2 alternates. We could put as many alternates as you want. And that was our suggested language. It was left out of the support materials that was to be given to you, so you could make a decision on what you wanted in there for language. As it's currently written, it is 1 assistant. But our suggestion would be, our proposed language addition to that, to go back to LCB, would be that we allow multiple people listed on the permit. And the restriction would then be only 1 of those people could act in that capacity at a time while accompanying the disabled hunter.
Captain Maynard, I believe that's what I'm hearing from the commission, that we would like to go. Unless there's a commissioner that has a comment on that, I think that's what I'm hearing from the commission.
Okay, so no limit on the number of people, in theory, as long
Just
as
one
there's only 1
designated.
actor.
Yeah.
Okay.
Any further comments from the commission?
I'm just thinking from a paperwork perspective, I mean, how long of an application are you going to, I mean, usually, like, for instance, I'm just thinking of other limitations I have in my life. Who's going to pick up your child if you can't pick them up? 3 to 5 spots or something of that nature. I mean, unlimited, what they attach a sheet of, I mean, where does it, should we give them some cutoff so they can put together the, or do they usually fill these out? Will they be online and you just keep adding and adding?
Where this is new, I don't think we have an answer for that, but I don't see someone coming in with a list of 500 people. I mean, I see a big number being 5 or 6 maybe.
But they do have to kind of scrub. Each person must meet those credentials, or you just state that they do,